Section 31 of Tribal Customs in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Customs in Anglo-Saxon Law by Frederic Seebohm. Chapter 13, Early Anglo-Saxon Custom, Part 4. 6. The Geithskund and Corlisk classes in their connection with land. Pursuing the question of division of classes mentioned in the Dooms of Ina, we turn now to the consideration of the most prominent distinction which runs through the clauses of the Dooms, viz., that of Geithskund and Corlisk. Roughly speaking, the two distinctions may have been gradually coming more and more to mean much the same thing. As a rule, no doubt, in King Ina's time, Corlisk men were twi-hind and Geithskund men 12-hind. The same class which, regarded from the point of view of the Vergeld, possessed completeness of kindred and the 12-hind oath, when looked at from another point of view, was Geithskund, i.e., more or less directly in the service of the king and belonging to the official and landed class. So that the value of the oath of both 12-hind and Geithskund men may have become easily associated with a territorial unit of 10 hides of land. Now, the fact of the connection of the value of the oath with 10 hides of land is pretty good proof that for practical purposes and in common usage, the holding of 10 hides was looked upon as in some way or other a typical unit of holding of the Geithskund or landed class. There is nothing new in this suggestion, but its lack of novelty does not detract from its value. And an examination from a tribal point of view of the isolated passages in the Dooms of Ina relating to this typical holding of 10 hides may possibly throw further and useful light upon the position of the Geithskund class. While we speak of the Geithskund class as almost equivalent to the landed class, it is obvious that it would be wrong to consider every Geithskund man as a land owner. Attention has already been called to the following clause. 51. If a Geithskund man owning land neglect the fyrd, let him pay 120 s, and forfeit his land. One not owning land, 60 s. A Corlisk man, 30 s, as fyrd white. The Geithskund man not possessing land may either be one who has forfeited his land, or a cadet of the class not having yet attained to the position of landholding, and yet being Geithskund by birth. Nor would it do to let modern notions of land ownership intrude themselves so far into the question as to make us regard the Geithskund and landed class as a class of land owners in the modern sense. If the typical holding of 10 hides be that of the Geithskundman, we may have to regard him rather as a Geiths of the king put into possession of the 10 hides by way of stewardship than as anything like the absolute owner of them. The typical holding of 10 hides may perhaps be usefully regarded, from a fiscal point of view, as a unit for purposes of revenue, at a time when that revenue under tribal custom consisted chiefly of food rents paid in kind for the king's or the chieftain's use. Clause 70 of the Dooms of Ina fixes in detail the food rent of 10 hides to fostre or on feorn. If the unit of 10 hides were not the customary unit for these food rents on the royal domains, why should the details of the food rent of 10 hides have been made the subject of an isolated clause like this? Again, if we turn to the grants made by King Ina to the monasteries, they become unintelligible if the system of management of the royal domains in units and multiples of 10 hides may be understood to underlie them. When Ina grants to Aldhelm, then abbot of Malmesbury, 45 cassati in the county of Wilts, the grant is found to consist of groups of manentes in 4 different places, and the groups consist of 5, 20, 10, and 10. When Ina makes a grant to Abbot Bernarald of land in Somersetshire, it consists of 3 groups of 20, 20, and 20 cassati, or manentes from 3 different estates. And when he makes a similar grant to Glastonbury, it consists of 10, 10, 20, 20 hides, and 1 hide in 5 different places in Somersetshire. So also when Bede mentions the donations by King Auzi to the Abbess Hilda of 12 possessioncula terrarum, he adds that 6 were in the province of Deira and 6 in Bernicia, and that each of them consisted of 10 familiae, so that in all there were 120. Now it would seem that as ealdormen were set over shires, so Gaisken men may have been set over smaller units of 10 hides, or multiples of 10 hides, holding them as laneland, not only for services rendered, but also with some kind of subordinate official or even judicial functions. Schmid long ago pointed out that the translator of Bede in 6 passages translated the Latin comes by Geis or Geiskundmen. This seems to imply that his position was in some sense an official one, subordinate indeed to the ealdormen's, as we may also learn from the translator of Bede. For while he translates the via comitis of Bede as the Geith's house, he translates the via regis as the residence of the king's elder, Bado signes eldor. We found in S. 45 of King Ina's laws, above quoted, that the Geithkinsman Bergpreis was 35 skillings, while the ealdorman's was 80 skillings. Still, though the lowest official in the scale, it was something that he should be named with the king, the ealdorman, and the king's thane, as having a Bergpreis, according to which he was to make legal denial, and sakon. The omission from this clause as to Bergpreis of classes below him seems to mark that while even the Korlisk man, i.e., even the Gefelgelde or Geber, was responsible for the peace within his flet, and received a fight white when it was broken by fighting in it, the Geithskundmen belonged to the class with some sort of extra jurisdiction beyond that which attached every man whose homestead was by long tribal custom a sacred precinct. And there is a clause in the laws of Ina which seems to refer to the something like judicial duties of the Geithskundmen, for it shows that the neglect of them causing a suit which he ought to have settled to be carried to a higher court, before the ealdorman or the king, deprived him of his right to share in the white raden, whatever they were, appertaining to the suit. Gif Geithskundmen thingad wid seinig appa wid keiniges ealdormannen for his inhuiwan appe, wid his halford por theo appe for frige na ha per nan veterden se geised for pon he him nolde ir leifels gesterian et ham. 50. If a Geithskundman has a suit with the king, or with the king's ealdorman for his household, or with his lord for bond or for free, he, the Geist, shall not there have any whereten, because he would not correct him before of his evil deeds at home. That he had special duties to discharge in connection with the feared was shown not only by one of the qualifications of the Geithskin status, being the possession of a coat of mail, helmet, and over-gilded sword, but also by the fired white of 120 skillings and the loss of his land if he neglected the fired. That he was put into his landed position under conditions to secure the management of the land for the provision of the king's gefal is shown by the following clauses, which in regard to one important particular at least point out what was expected of him, and further suggest that there was reason to fear that sometimes he might be inclined to desert his post without having performed the conditions upon which his land was held. Bei Geiskunds mon fair. Gif Geiskund mon fair thon mot se haben her Gerafan mid him 7 his Schmid, 7 his killed Festren. Se hafed 20 Hilda, se scale Teknan, 12 Haida Gesets lands thon hin fairen will, se hafed 10 Haida, se scale Teknan, 6 Haida Gesets landes. Se pahaba preo Haida takne oders helfs. If a Geithskund leaves the land, 63. If a Geithskund leaves, then may he have with him his reeve and smith and his foster nurse. 64. He who has 20 hides, he shall show 12 hides of Geset land if he want to leave. 65. He who has 10 hides shall show 6 hides of Geset land. 66. If he have 3 hides, let him show 1 1/2. These clauses suggest very clearly that the Geizkind man had been entrusted with 10 hides or 20 hides, or sometimes a smaller number, under the special obligation to provide the food rent by settling tenants upon the land. Let us pass, then, to what evidence the dooms of Ina afford as to the customary method of settling tenants on the land. The very next sections to those just quoted are as follows. Begarda Londens. Gif mon Gethingath Geard Landes Opa Mer, to Rad Gefal 7 Gareth, Gif se Halford him Wal P land Araren, to where 7 to Gefal, ne perf he hem onfon gif he him non bottle ne seld, 7 poli para acera. Gif mon Geiskunde monen adrif, fordrif, pi bottle, nes para seten. Of a yard land. 67. If a man agrees for a yard land or more to Gefal and plows it, if the Lord wants to raise the land to work into Gefal, he need not take it upon him if he, the Lord, does not give him a bottle and let him give up the acres. 68. If a man drive off a Geiskindman, let him be driven from the bottle, not the seten. Working from the known to the unknown, in a former volume we found that under the open field system of husbandry, the hide at the time of the Domesday survey and earlier was generally held to contain 4 vergets, or yard lands, and that so far as arable land was concerned, each yard land was a bundle, so to speak, of about 30 scattered strips or acres. Tracing the yard land further back, the interesting point was gained from the 10th century document known as the Rectitudines, etc., that in some regions the custom in allotting a yard land to a tenant, called a geber, was to give him with his yard land to land seten, 7 acres already sown, and a pair of oxen, and certain other things theoretically by way of loan, so that on the geber's death everything returned to the Lord, though in practice the holding and land seten were no doubt continued to his successor on payment of a relief. And this system of settling gefogeldas and gebers, or whatever such tenants might be locally called, on yard lands, seems to be that alluded to in the Dooms of Ina. The clauses incidentally referring to gefogeldas, gebers, and yard lands thus become intelligible and important in the light of the later evidence. This I endeavored to show in a former volume. Now this system of settling tenants on yard lands by allotting to each a pair of oxen, so that 4 of them should be able to combine in forming the common plow team of the hide, obviously belongs to a time when agriculture had become sufficiently important for the unit of occupation, and so of gefo paying and services, to be generally agricultural rather than pastoral. But while the hide thus seems to have been connected in the Dooms of Ina mainly with arable farming, it does not follow that it always had been so everywhere. The word hide may have originally been applied to a holding devoted more to the grazing of cattle than the growing of corn. The remarkable document, which has been called the Tribal Hidage, to the meaning and date of which Mr. W. J. Corbett has opened our eyes, shows that 40 or 50 years before the date of the Dooms of Ina, the whole of England, then subject to the Anglo-Saxons, was, as we should say, rated in hides according to its tribes or megaths, possibly for the fiscal purposes of the Bretwaldership. And it would seem likely that under common designation of hides, pastoral as well as agricultural units for food rents must have been included. This seems to be indicated by the fact that the hides and veergates of the pastoral districts of West Wales in the Exon Domesday Book are many times greater than those of other parts of England, and vary very much in area. In the pastoral or grazing districts recently conquered from West Wales, early tribal usage would be very likely to survive, and there may well have been some continuity in the methods of tribal agriculture. Judging from what we know from the Cymric codes, there might not yet be permanent division of the fields into strips and veergets, but rather co-aeration of such portions of the waste each year as suited the requirements of the tribesmen. The open field system of agriculture was, in its main principles and chief methods, common to German and Celtic tribes. But we are told that the Germans knew nothing of cooperative plowing and the team of 8 oxen on which the agricultural heightage of England was so clearly based. For the team of 8 oxen, we must go to the Cymric codes and the practice in the Isle of Man and Scotland. It was common to these Celtic regions, even to its details, the yoke of 4 oxen abreast and the driver walking backwards in front of the team. In such a matter as method of plowing, there may well have been continuity. We seem to see in the laws of Ina the process going on of transition from the tribal form of the open field system, the co-aeration of the waste, to the more fixed forms of settled and permanent agriculture. Thus, without pressing analogies too far, there may be a root of tribal custom discernible even in the system of settling gebers on yardlands. Something very much like it was followed on the continent under Roman usage. But the case of the veteran to whom a pair of oxen with seed of 2 kinds was given as his outfit only partly resembled the case of the geber. In the case of the geber, the outfit of oxen remained in theory the property of the lord and returned to him on the death of the tenant. This was the essential point which created the semi-servile tenancy. With the homestead went the setain, or outfit, and the corresponding obligation, not only of gaffel, but also of week work, and out of the peculiar relation so established may have grown up in West Wales, as in Wales itself and Ireland, very easily the doctrine that after its continuance for 4 generations the tenant became adscriptus glebe. The allotment of stock by the Irish chieftain formed, as we have seen, in a cattle breeding rather than an agricultural community, the traditional tie between himself and his tenants, whether tribesmen or strangers. The Cymric chieftain of a kindred followed very nearly the same traditional practice when he gave to the young tribesman on his attaining the age of 14 his da, or allotment of cattle, for his maintenance, thereby establishing the relation of man and kin between him and the chief. The same tribal principles were, moreover, applied to strangers both in Ireland and Wales. The Irish feud here, thus settled on the chieftain's land, became, as we have seen, after 4 generations, adscriptus glebe, and so did the Ailt, or Altude, settled on the Cymric chieftain's land. And the same number of generations attached the nativus to the land under early Scotch law. Now, if under tribal usage this was so, it need not be surprising that in the newly conquered districts of West Wales, or more generally in Wessex at the time of King Ina, when the extension of agriculture was an immediate necessity, something like the same traditional system should continue or come again naturally into use, producing something like the same kind of dependence of one class upon the other. It is necessary to point out that this method of settling tenants on yardlands with an outfit of a pair of oxen, etc., was more or less general, because doubts have been recently thrown upon it. Its prevalence as a custom does not rest entirely on the evidence of the rectitudines, but on several incidental mentions of it in various and distant quarters. For instance, in the will of a reeve named Abba of Kent, about A.D. 833, it is the gift of a half swulung, i.e., what else would have been described as half a hide, and with that land were to go 4 oxen, 2 cows, and 50 sheep, that is, 2 oxen and 1 cow, and 25 sheep to each gioch or yardland. And again, the Inquisition of Glastonbury, A.D. 1189, describes the holder of a yard land almost in the same terms as those used in the rectitudines, in the description of the geber. He is said to hold a yard land for 32 d, probably 1 d per acre, and every Monday he must plow a half acre and harrow it, and he works every day in the week but on Sunday. He has from his lord 1 heifer of vernum, and 2 oxen, and 1 cow, and 7 acres of corn sown, and 3 acres of oat to start with, 10 acres in all sown, and 6 sheep and 1 ram. King Ina made grants of land, as we have seen, to Glastonbury, and it is interesting to find the custom of allowing 2 oxen, 1 cow, and 6 sheep to the yardland, as described in the rectitudines, still going on in West Wales 500 years after Ina's time on the estates of the abbey. Take again the charter MLXXIX mentioned by Kemble, I p. 216. This charter shows that the Bishop of Winchester, A.D. 902, had leased 15 hides of land to a relative of the bishop, requiring that he must settle there, in Berthon, men who would be fixed, Hametan, to the place. He himself had Hamet Luf and her 3 barons, and Luhan and his 6 barons, and these must remain on the land, whoever might hold it. There were also 3 white theows, Berberde, and 3 more Theauberde belonging to the bishop, with their descendants and higher team. At this date, the settling of new tenants, may we not say, some of them as Gebers and some as Theows, was still going on in Wessex, A.D. 902. It is quite true that the holders of these yard lands are not everywhere always described as Gebers, but we are dealing with the thing, not the name. The word Geber, however, was of much wider use than merely in 1 or 2 localities. It is not only in the Rectitudines that the Geber and his services are mentioned. On the Tiddenham Manor of King Edwy, on the Gasset land, there were Gebers with yard lands, Geerdedefallenens, as mentioned in the former volume, page 150, and other examples may be quoted. In the Will of Winfled, there is mention of lands at Shaftesbury and the Gebers that on those Gefallens sit. Paragebura di on Pam Gefallens sitath. And as incidental evidence that the Gebers became in course of time adscripti glebe, it is worthwhile to remember that early in the 11th century the monks of Ely, in connection with their manor of Hatfield, kept record of the children of the Gebers on their estates who had married with others of neighboring manors, so that they might not lose sight of them and their rights over them. And the importance with which their rights were regarded is emphasized by the fact that the record was kept on the back of an ancient copy of the Gospels, belonging presumably to the altar of St. Ethelreda. Now, if such in part was the relation between the Geithskenmen and the tenants of the yardlands of his Gesset land, arising from the allotment or loan of stock, may not something of the same kind lie at the root of the relation between the Geithskenmen himself and the king? Lord as he may have been over his Corlisk Gefalgeldas, was not the Geithskenmen himself a servant of the king, looking after the king's Gefel, a kind of middleman tied to his post with the elder man above him in the hierarchy of royal service, liable to lose his land if he neglected his duty? It is an interesting question how far the Corlisk class were adscripti glebe under the laws of Ina, but when we try to find this out, we discover that both classes seem to be under some kind of restraint as to going away. Faire. If a Geithskenmen fare, we have seen under what restrictions it must be. There is another clause which deals with the case of persons who shall fare without leave from their lords. Gifhwa fare anleft from his halford, ape on other skir heine, bestella 7 heine mon gesig, fare per he with 7 gesella his halford, 60 skill. S. 39. If anyone go from his lord without leave, or steal himself away into another shire, and he be discovered, let him go where he was before, and pay to his lord 60 skillings. Judged in the light of later laws to the same or nearly similar effect, this clause must probably be regarded rather as early evidence of the relation between lord and man, established generally for the maintenance of the public peace, than as bearing directly upon the question of the attachment of the smaller class of tenants to the soil. And yet, if the relation of the ordinary freeman to, let us say, the elderman of the shire was such that he might not move into another shire without leave, and until it was ascertained whether his action was bona fide, or perhaps with the object to escape from debt or vengeance for a wrong committed, the restriction would be likely to be still stronger when a tenant was under fixed obligations to his lord, or had, by taking a yard land and homestead, settled on his lord's land, and accepted stock under conditions of gefil and week work regulated by general usage. The idea of freedom as a kind of masterful independence of the individual was not one inherited from tribal modes of thought, nor likely to be fostered by the circumstances of the times which followed upon the Anglo-Saxon conquest of Britain. When this fact is fully recognized, the gulf between the Geithskund and Corlisk classes does not seem so deep, after all, as it would be, if instead of approaching the question from a tribal point of view, We were looking for allodial landowners on the one hand, and expecting the choral to be a member of the village community of independent peasant proprietors on the other hand. But we are not doing this, and returning to the Geisskundmen, perhaps we have, after all, taken for granted quite enough that the general environment in Wessex was agricultural rather than pastoral. Even as regards King Ina himself, there may have been a good deal of the tribal chieftain still left in his relations to his Geiskund followers and officials. We have spoken of his tribal food rents, but how did he gather them? No doubt the king's gaffel may partly have been paid in money, but so far as it was paid in kind, it must have been carried by his tenants to his Winchester Palace, or one of his other manors, according to the system prevalent at the time, followed for centuries after in West Wales, viz., the system of the night's entertainment, firma unius noctis, a system followed by tribal chieftains and their royal successors in Scandinavia as well as in Britain. When the Domesday survey was made of what was once West Wales, there was found still existing, especially in Dorsetshire, the survival of a very practical arrangement of royal food rents, which may have been in use in King Ina's time and date back possibly before the West Saxon conquests. Some portions of the terra regis scattered about the county of Dorset are grouped in the survey so that each group might supply the firma unius noctis, the money equivalent of which is stated to be 104L, i.e., 2L per night's entertainment for one night each week in the year. This mode of providing the firma unius noctis is illustrated by the legend which represents King Ina himself and his queen as moving from manor to manor for each night's entertainment, their movable palace of poles and curtains being carried before them from place to place upon sumpter mules. Now, if we might regard the Geisskundmen as one of a class to whom 10 hides or 20 hides had been allotted by King Ina on a system providing in this practical way inter alia for the night's entertainments, it would be natural that the food rent of the unit of 10 hides should be fixed. And further, it would be natural that if the Geisskundmen should wish to throw up his post and desert the land entrusted to his management, he should be restricted, as we have seen, by conditions intended to secure that the provision for the king's entertainment or gaffel in lieu of it should not materially suffer. We have seen that as the ealdorman was to lose his shire if he let go a thief, so the Geisskundman was to pay a fyrd and to lose his land if he neglected the fyrd. It was possible then that he might have to be evicted. And a clause in the Dooms of Ina has already been quoted which seems to refer to the eviction of a Geiskundman. Begeiskundes mons dref of land. Gif mon Geiskunde mannen a drif, for drif pi botel nes pere seten. 68. If a Geiskundman be driven off land. If one drive off a Geiskundman, let him be driven forth from the homestead, botel, not the seten. If he was evicted, he was to be driven from the botel, or homestead, not the seten. What can the seten have been? The land granted or entrusted to the Geiskundmen for the performance of corresponding duties is not likely to have been mere waste. Part of it might surely already be geset land, let to tenants of yardlands. On the rest of it, still held in demesne, there would probably be some herds of cattle. In these early days, the cattle and corn on the land were far more valuable than the mere land itself. If, therefore, a fixed food rent was payable to the king, may it not be inferred that sometimes the typical holding of 10 hides included the stock let with it, just as, according to the rectitudines, the yardland did? Following strictly the analogy, the original stock on the land and in the hands of the tenants would be the seten of the Geiskundmen, theoretically, like the land itself, belonging not to him, but to his lord. It might have been sometimes so, but at the same time there might be other cases in which the possession of cattle may have led to the tenure. The coral or the whale, who had risen to having 5 hides, might have brought the cattle or seten with him, and to evict him from his own cattle and crops, as well as from the bottle, might be unjust. The text as it stands seems to mean that the Geiskundman is not to be evicted from the seten, and the clause seems to be intended to protect his rights and to prevent his being evicted from his own stock and crops on the land. The clause is not clear, but it adds to the sense that in the case of the Geisskindmen, we are not dealing with a landowner who can do what he likes with his own, any more than in the case of the Korlisk Gelfageldas, we are dealing with a class of peasant proprietors. Difficult as it may be to come to a clear understanding of some of these isolated passages in the Dooms of Ina, they may at least have saved us from the pitfall of a fatal anachronism. Their difficulties, forcing us to think, may in some degree have helped us to realize the point of view from which the two classes, Geisskund and Korlisk, were regarded in early Wessex legislation. Throughout Wessex, speaking generally, they seem to have been regarded as the two prominent classes in practical agricultural life. The general facts of everyday observation marked off the Geisskindmen as belonging to the ruling class, holding land direct from the king as a king's Geiss, while the Korliskmen, speaking generally in his relation to land, was the Gefogelde, or Geber, sometimes probably holding his yardland on the king's dems, but mostly perhaps more and more often as the tenant of the Geisskindmen. This, it would seem, had become so general that in King Alfred's day, and perhaps even in King Ina's, ignoring the exceptional classes between the Geisskund and the other class, there was no absurdity in King Alfred's claiming that equally dear with the Danish Lysing, the Kurl who sits on Gaffel land, should have a Twyhind Weregeld. The division into Geisskund and Korlisk classes was doubtless a somewhat rough and wide generalization. There were, we know, men without land who belonged to the Geisskund class, and Kurls who were not tenants of yardlands. And even among the tenants of yardlands, some paid Gaffel only, and others both Gaffel and weak work. But for our purpose, the fact to be noted is that the generalization was sufficiently near the truth for it to be made. We must not infer that these two classes included strictly the whole population. Judging from continental evidence, Wessex must not have been very exceptional indeed if there were not everywhere numerous theos or thralls. From this class, Anglo-Saxon wills and other documents show that there was a constant stream of freedmen or theos who by emancipation were allowed to creep up into the Korlisk class, partly as the result of Christian impulse and partly, probably, from the lack of tenants to occupy the yardlands left vacant by the desolation caused by the constant wars. Thus, while broadly speaking the Geisskund and Korlisk classes may have corresponded to the 12-hind and Twyhind classes, they were not absolutely identical. The two lines of distinction had not the same origin and did not run absolutely parallel, but they may well have worked in the same direction. The original distinction, founded upon the possession or absence of the perfect kindred and hindens of oath helpers, was rooted in tribal instincts and never wholly extinguished throughout Anglo-Saxon history. The Geisskund class, most perfect in their kindred and nearest in their relation to the king, influenced perhaps by traditions of Roman land management, naturally grew up into 12-hind and landed class, while the Korlisk class, recruited from outside and from below, just as naturally became their tenants. Thus, in England, as elsewhere, we may easily believe that the gulf between classes resulting from tribal instincts and confirmed by difference in weregelds was hardened and widened by the conditions of landholding in the conquered country, which tended to raise the one class more and more into manorial lords and depress the other into more or less servile tenants. The compact between Alfred and Guthrum affords the strongest evidence that already in King Alfred's time the process was far enough advanced for a pretty hard line to be drawn between them. 7. Comparison of Wessex and Mercian weregelds with those of continental tribes. Before passing from the Wessex to the Kentish laws, it may be well to mark the position to which the evidence hitherto examined has brought us with regard to the amount of the weregelds. We have had again and again to come back to the question of the status of the 12-hind and the Twyhind classes as shown by their weregelds. By the compact between King Alfred and Guthrum, the English weregelds were brought into line with Norse and other continental weregelds. The statement of the higher weregeld in gold made possible a comparison of the Anglo-Saxon with continental weregelds. The result of the inquiry into the continental weregelds of the full freemen was that they seemed to fall very distinctly into two classes. The Frankish and Norse weregeld of 200 gold solidi on the one hand, and the Frisian, Saxon, Alemannic, Bavarian, and possibly Burgundian weregeld of 160 gold solidi on the other hand. The ratio between these two weregelds is as 5 to 4. Now, this is exactly the ratio between the two 12 hind weregelds of the Anglo-Saxon laws, i.e. of Wessex and of Mercia. Both were of 1,200 skillings, but the Wessex skilling was of 5 pence and the Mercian of 4 pence. Finding 12 hind and twi-hind weregelds in the laws of Ina, we seem to be bound to regard the distinctions between the two classes as going back to a time 2 centuries at least before the inroads of the Northmen. The position of the dooms of Ina as they have come down to us, annexed to the laws of King Alfred, might possibly have raised a doubt as to whether the incidental mention of the weregelds might not have been inserted in the text by the scribes of King Alfred. But if the Mercian weregelds were of ancient tradition, independently of the Wessex evidence, the statement of the Wessex weregelds in the dooms of Ina need not be doubted. At the same time, the amount of the Wessex weregeld is confirmed by the weregeld of the secular thane in the Northumbrian statement, for 2,000 thrithmas are equal to 6,000 pence, and thus the weregeld of the thane accords with the Wessex 12 hindmen's weregeld. And as this statement seems to have been rescued from times anterior to the Northmen's invasion, it is so far independent evidence. In the same document, the Corps' weregeld of 200 Mercian skillings is also mentioned. The concurrence of independent traditions thus seems to trace back the difference between the Wessex and Mercian weregelds, as well as the difference between the 12 hind and twi-hind classes in both cases into the early Anglo-Saxon period. And if we may date them back to the time of King Ina, 2 centuries before the invasion of the Northmen, they may well go back earlier still. For weregelds which have already become traditional in the 7th century may not improbably have been brought by the invading tribes with them into Britain in the 5th and 6th centuries. The fact that the Mercian and Wessex weregelds differed makes it unlikely that the traditional weregelds were first adopted in Britain or acquired from the Romano-British population. That they differed exactly in the same ratio as the two classes of continental weregelds differed is a fact which points still more strongly to a continental origin. Moreover, the Wessex and Northumbrian weregeld of 1,200 skillings of 5 pence, i.e. 6,000 pence or scaets at a ratio of 1 to 10, was equal to 6 tremises or 200 gold solidi. The Mercian weregeld of 1,200 skillings of 4 pence, i.e. 4,800 pence or scaets, at the same ratio was equal to 480 tremises or 160 gold solidi. That the ratio of 1 to 10 was not an unlikely one is shown by its being the ratio under the Lex Scalica between the 40 scripula of silver and the gold solidus before the Merovingian reduction of the standard weight of the latter and the issue of silver tremises. It was also the ratio at which 12 Roman argenti or drachmae of silver were apparently reckoned as equal to the Merovingian gold solidus. The correspondence at this ratio of the Wessex 12 hind weregeld with the Frankish weregeld of 200 gold solidi, and of the Mercian 12 hind weregeld with the other continental weregelds of 160 gold solidi, is sufficiently striking to be taken into account in any speculation as to the respective origins of the West Saxon and Mercian invading tribes. But that is not the object of this essay. It is enough to have noted a fact which may or may not turn out to be of some historical significance. The value of the weregelds to this inquiry consists in the light they throw upon the solidarity of tribal society and the position and social rank of the various classes of Anglo-Saxon society. But we have yet to examine the laws of the Kentish kings, and it will be best to suspend any further judgment on these points until this remaining part of our task has been done. End of section 31.